Hello students, my name is Liz Attia and today's topic is the doctrine of precedent and divisions of law. Okay, so what is precedent? So first of all, we need to actually outline the divisions of law within the Australian jurisdiction. We have the criminal law and we have the civil law system. So criminal law, causes of action are actually brought about by the state from an alleged breach against the state. So I guess if you like to consider it as we all live in a community where legal rules are applied for the protection of the society. And in criminal law, you're considered to have breached the very legal rules that work to ensure the ongoing safety of civilians within that system. So your breach is not just to the victim, but in fact it's to the state because you've broken the rules of the state. So criminal law is quite different to civil law. In civil law, your breach is to another individual. So an individual or a corporation. So criminal law is action brought by the state against particular people, and in civil law, it's actually between individuals or between corporations. The doctrine of precedent is quite integral to our Australian legal system. It's integral to our common law, and it's when a court decides a case, the reason for that decision can become a precedent for future cases. So in this way, the law develops a body of case law that's applied to future judgments, and this is sometimes known as judge-made law. So the process by which court cases are decided in and of themselves become law for future cases with similar facts. And that becomes really important because it actually binds judges and binds future courts on considering the deliberations and the decisions for similar cases in the future. So courts are bound by precedent, and lower courts will actually be bound by decisions of higher courts, and that's known as binding precedent. So the lower courts of the local court, the district court, are bound to follow decisions made by the Supreme Court, the New South Wales Court of Appeal, and superior courts such as the Australian High Court. When a court is not bound by another court's judgment, so if they're actually courts at the same level in terms of the court hierarchy, then it's persuasive precedent, it's not binding precedent, which means that the rationale and the decisions and the arguments for and against considering particular circumstances and which way the decision should go influence those courts, but they're not bound to actually follow them. So it's persuasive in nature as opposed to obligatory. And that's when we're actually talking about courts at the same level or of an international jurisdiction. So only courts in an Australian court system would actually have binding precedent. That's important. Okay, how does that fit then into what we actually call the Australian separation of powers? How is law actually made? Well, powers in terms of our law making and who gives the courts and who gives the legislature the power to make those courts are actually set out in the Australian Constitution. So in Australia, we actually have the legislative power, which is actually Parliament passing law, enacting statutory legislation such as acts, the executive power, which come up with protocols and procedures that administer the law, that talk about the law in action, how to actually make this legislation operate. And then the judicial power, which is the courts, who interpret what the law actually means in particular circumstances based on facts and the particulars of the factual information. So judges will be very clear to actually say to you, well, listen, we don't make law, although they do in terms of binding precedent, but we interpret what the law actually means. So we use the legislation in the intent of what the acts are designed to do and actually apply it to particular situations. So the Constitution actually divides and defines how power is divided in the Commonwealth and states to make law. And this is particularly under Section 51 of the Australian Commonwealth Constitution. So it lists the powers of both the Commonwealth, the federal government, as well as the state and territory. The state and territories. So Section 52 lists some of the exclusive Commonwealth powers, so what actually falls under the Commonwealth government's jurisdiction alone, for example, migration, for example, defence, for example, marriage. So this is an exclusive Commonwealth power. Section 109 says that when there's actually an inconsistency between a Commonwealth power and a state power, such as, for example, health or education, the Commonwealth power will actually be given precedence. So the Commonwealth law will override the state law if there's some inconsistency. And just keep that in mind when we talk about euthanasia, because that becomes important. Matters not listed become residual powers. So anything that's not an exclusive Commonwealth power becomes a state power as a residual power of the states, noting what I actually said in terms of inconsistencies there between state and federal legislation. Thank you, students. That brings today's topic to an end.